The Senate Judiciary Committee hearing room hummed with anticipation as the microphone in front of former Florida Attorney General Pam Bondi awaited. Camera shutters clicked as she strode purposefully, adjusting the microphone before her. Her sharp blue blazer stood stark against the wood-panel background of the aging chamber. Supreme Court Justice Amy Coney Barrett sat at the far end of the room, ready, her expression unreadable behind the professional mask of an experienced jurist. "Thank you for allowing me to address you today," Bondi began, her voice strong and assertive. "I am here before this committee with evidence that will turn all we thought we knew about the Justice Barrett appointment process on its head." The atmosphere shifted in a heartbeat. The room fell silent as Bondi extracted a sealed folder from her briefcase, boldly marked "Confidential" in red letters. "What I'm about to reveal," she continued, "exposes a secret arrangement that predates Justice Barrett's confirmation, an arrangement she has never disclosed to this committee or to the American people." A flicker of tension passed over Barrett's face, her eyes widening as the folder was opened. Members of the committee leaned in, expressions turning to disbelief. The chairman reached for his gavel, but it was already too late. The revelation had begun. Pam Bondi had not expected to be at the center of such a storm. Renowned for her prosecutorial zeal and commitment to conservative values, she had served as Florida's first female attorney general from 2011 to 2019 before returning to private practice as an attorney. She remained connected to high-level conservative circles and respected for her straight-shooting style and advocacy of government transparency. 3 weeks prior, a mysterious letter had appeared in her office. No reply address, no note, containing documents that appear to detail a previously unpublicized deal related to Justice Barrett's 2020 confirmation. Bondi had sat for days studying the documents, verifying their authenticity with ethics and legal counselors. "This is not political," she had told senior aides. "If this is real, the American people deserve to know, especially before more historic rulings are handed down." Amy Coney Barrett's path to the Supreme Court had been meteoric. A retired law professor at Notre Dame and appeals court judge on the Seventh Circuit Court of Appeals, she had been nominated and confirmed in October 2020, shortly after Justice Ruth Bader Ginsburg passed away. Conservatives hailed her for her originalist judicial philosophy and devout religious faith, but she also became a lightning rod for criticism from the left. This particular judiciary oversight hearing had been expected to proceed without drama. Barrett had voluntarily appeared as part of the court's broader efforts to maintain transparency and communication with Congress. Nothing had suggested the hearing would deviate from routine. But Bondi's documents changed that. She addressed the room a second time, her tone assertive. "The reports I've gotten indicate that before Justice Barrett's confirmation hearings, there was some sort of unofficial agreement about how she would deal with certain types of cases." Murmurs swept through the room. Senator Richard Blumenthal cut in quickly. "Ms. Bondi, these are serious charges. Can you be more specific regarding the character of this agreement?" Bondi nodded and pulled out the first page from her folder. "This is an exchange of emails between two top officials of the last administration, September 18th, 2020, 3 days before Barrett's nomination announcement." She placed the paper on the overhead projector. The email was discussing a mutual understanding with ACB on how to deal with cases in the future. While diplomatically phrased, the implication was obvious. Some outcomes were being quietly assured. Justice Barrett leaned forward to answer. "These emails, if real, do not include me as a recipient, Ms. Bondi. I never participated in such an exchange." "That's correct, Justice Barrett," Bondi asserted. "Your name is not on that one. But the next paper addresses that." She showed a calendar entry showing a scheduled private meeting between Barrett and the officials who were the recipients of the email, scheduled for the day after the email was sent. The committee chairman cut her off. "Ms. Bondi, Supreme Court nominees have routine meetings with administration officials. A notation on a calendar doesn't prove anything improper." "I understand your point, Mr. Chairman," Bondi replied. "That's why the third paper is so significant." She paused for dramatic effect. It's a memorandum by one of the meeting participants summarizing what was discussed and sent to 3 others within the administration. As the memo scrolled across the screen, a rumble of gasps spread through the room. The memo listed potential legal questions likely to face the court and sketched Barrett's overall positions on each. Worse, it quoted mutual commitments to come to agreement on positions in a series of hot-button areas of law. Senator Josh Hawley glared at Barrett. Justice Barrett, did this meeting take place? Did you state what this memo reports? Barrett's expression furrowed. Senator, I had numerous meetings throughout the confirmation process. I don't particularly remember every one of them, but I can say absolutely clearly, I never promised anything about how I'd rule a case in the future. That would be inappropriate. Bondi pressed forward. Justice Barrett, please turn to page V3 of the memo. It details your concern over how the discussions might appear if they became public. The room fell even more silent. The document suggested Barrett had asked for confidentiality about certain elements of the conversation, citing concern over how they might be perceived. Senator Ted Cruz fired back. This entire episode is based on unaudited documents and unidentified sources. This doesn't even have a place in a congressional hearing. Bondi was ready. Senator Cruz, I see, which is why the documents have been through 2 impartial forensic examiners. She produced affidavits from digital forensic specialists who'd verified the metadata and the document's contents. And also, she continued, holding up another folder, I have a sworn affidavit from a witness who was at the meeting. The individual, a former Justice Department official, has come forward only recently due to questions about recent Supreme Court decisions that precisely track what's contained in these documents. The hearing room tension was at its highest as Bondi identified the whistleblower, a mid-ranking DOJ official who had taken minutes at the meeting and only just understood the ethical consequences of what had occurred. Justice Barrett, remaining composed but clearly shaken, requested a recess to discuss with her legal counsel. The chairman consented to the request, noting the justice's clear distress. As Barrett and her lawyers were escorted to a back room, cameras caught the tension spreading over members of the committee. The routine oversight hearing had become a crisis, one that could undermine the power of the country's highest court. Aides and senators congregated in the break. Democrats hurried to assess the scope of the revelations. Republicans appeared divided, hesitating on whether to defend Barrett or distance themselves. Law experts flooded social media with real-time analysis of the constitutional implications playing out. 15 minutes later, Barrett arrived. The confidence that normally characterized her presence had been replaced by an evident burden. A note in handwriting from her attorney was handed to her as she sat down. She then asked to address the court. I have reviewed the documents presented by Ms. Bondi, she said quietly. I take seriously these allegations. They target the very core of judicial independence and the oath I swore to uphold. She paused, then continued. The memo contains information that I do not recall and do not recognize. But rather than dismiss them, I believe that the integrity of the court demands a full and independent investigation. The room gasped. Many expected a stern denial, instead of an offer for further investigation. Bondi believed the moment of crisis had finally come. Justice Barrett, thank you for your honesty. But one more piece of evidence. She pulled out a final page from her file. This is a handwritten note purportedly signed by you in the very meeting in question. Bondi set the paper on the projector, and Barrett's distinctive handwriting unrolled onto screens throughout the room. The note was an abbreviated notes on various doctrines of law, with asterisks next to specific items, including the instruction to maintain SONF on points 1 to 3. Barrett studied the paper, her expression relaxing as she saw her handwriting. The room fell silent, everyone holding their breath for her response. What followed surprised everyone in the room. The handwriting is similar to mine, Barrett assented, but this letter has been produced out of context. Can I come to see the original? With permission, Barrett got up and walked over to Bondi's table. She examined the paper closely under the light, then gestured for her lawyer to follow. They consulted quickly before Barrett took her seat again, a new look of determination on her face. Mr. Chairman, Committee members, Miss Bondi, Barrett began, her voice more assertive now. I see this document, but not in the context which has been implied. This is what appears to be a page of my personal preparation notes before my confirmation hearings. Reaching into her portfolio, Barrett drew out a series of identical pages of notes. I had extensive preparation materials while going through the confirmation process, as any nominee would. The phrases mentioned by Ms. Bondi do not relate to secret agreements, but to confidential client affairs in my previous legal practice that I knew I couldn't discuss at the hearings due to attorney-client privilege, she explained, submitting her notes to the committee clerk. You can see the same abbreviations and marking convention used throughout my preparation documents. CONFARC is short for confidentiality, not confirmation, as has been suggested. Barrett addressed the memorandum directly. As for the summary of the meeting Ms. Bondi provided, I cannot account for its source, but I can say with absolute certainty that it misrepresents any discussions that I had as part of the nomination process. I would never make promises about future cases that would betray the judicial oath I have maintained in my entire career. The tone in the room changed overnight. Bondi, who seemed to have the upper hand moments earlier, was now having difficulty keeping her tale consistent. Justice Barrett, these explanations do sound convenient, Bondi said, referring to the whistleblower testimony. Barrett, a woman who didn't like to interrupt, interrupted now. Miss Bondi, you referred to a whistleblower who recorded this alleged meeting. Have those original records been made available? Bondi hesitated. The whistleblower testified from memory, and that's the basis of this memorandum, Bondi said. Barrett nodded. No contemporaneous notes from this person, so just a recent memorandum based on 2-year-old memories? The memorandum was drafted by the administration officials immediately following the meeting, Bondi claimed. Then why does its metadata, which your own experts certified as authentic, say it was composed last month? Barrett asked, revealing that her own team of lawyers had also rushed to examine the document properties in recess. The air in the room buzzed with whispers as Bondi seemed visibly caught off guard by this information, visibly not expecting Barrett to challenge the technical aspects of the evidence. Senator Ted Cruz pounced. Miss Bondi, are you saying that a document drafted last month is a reliable record of a meeting in 2020 with no contemporaneous notes and no recordings? Before Bondi had a chance to respond, Barrett was deadly. Mr. Chairman, my staff asked the alleged meeting date during the recess. I was not in Washington, D.C. on the date mentioned in these documents. I was giving a lecture at Notre Dame Law School, which was taped and had hundreds of listeners. She presented travel records and the lecture calendar as proof. Moreover, the two individuals I purportedly met with were both out of town that day as well, one in Texas and one in Florida, according to their public schedules. The room fell silent, the seriousness of the implications sinking in. The papers, as plausible as they seemed, contained a deadly factual defect that undermined their own premise. Bondi stood still at the podium, taking in the news. Her case was melting before her eyes. Barrett broke the silence, her tone not victorious but somber certainty. I acknowledge that the Supreme Court's work is contentious, and people of good faith can disagree with our decisions. But accusations of secret deals and moral transgressions require extraordinary evidence, evidence that respects facts and context. The chairman, noticing the moment had shifted, intervened. Miss Bondi, can you reply to Justice Barrett's points on the date of the document and the impossibility of the meeting? Bondi, her assurance shaken, admitted, I accepted these documents in good faith and had them authenticated. If there is a discrepancy in the timeline, then it should be investigated further. I repeat my concern about judicial independence, but I do see that Justice Barrett has raised some genuine concerns about this specific evidence. It was as much a concession as the moment permitted. Barrett's win was evident, not in aggressive confrontation, but in her methodical dismantling of the accusations with verifiable facts and background. The hearing concluded an hour later, but the repercussions were only just beginning. As Barrett exited the committee room, escorted by Capitol Police for extra protection, the hallways buzzed with congressional staff and journalists sprinting to attempt to make sense of what had occurred. Within minutes, Barrett documents and Bondi accusations were trending nationwide. News networks broke into regular programming to analyze the dramatic confrontation. Legal experts weighed in on the significance of the allegations and Barrett's response. Conservative media outlets framed the incident as an attempt to assassinate the character of a respected jurist. Documents debunked. Justice Barrett exposes false allegations, read the headline on one major right-leaning site, accompanied by footage of Barrett methodically dismantling Bondi's evidence. Progressive outlets were more balanced in their reporting. Barrett spurns contentious documents. Court independence doubts remain, acknowledging that the evidence had been challenged but still reporting doubts about the Supreme Court's trajectory. The unidentified whistleblower who had provided the documents to Bondi was not named, spurring wild speculation. Others speculated that it was an irate former clerk who sought revenge, but others wondered whether the entire affair had been a crafty scheme to discredit legitimate monitoring of the court. At dusk, 3 significant developments had followed. First, the chairman and ranking member of the Senate Judiciary Committee signed an uncommon bipartisan press release of inquiry into the origin of the documents. Though we may disagree on judicial philosophy, we are in accord in condemning the introduction into congressional proceedings of apparently forged documents, the release stated. Second, FBI forensic experts began to examine the documents to determine their true origin, including when and how they were created and if they were genuine templates that were recently changed. Third, several scholars of legal ethics collectively criticized the incident, noting that even if this specific accusation is valid, the episode raised deeper questions regarding the Supreme Court's confirmation process and the lack of binding ethics rules for the nation's highest court. Justice Barrett, who had been remarkably calm throughout the ordeal, issued a brief statement through the Supreme Court's Public Information Office. I appreciate the committee's openness to hearing all sides. The court's work goes on, under the Constitution and rule of law. Pam Bondi, being severely criticized and potentially facing professional consequences, was on a cordial cable news program that evening justifying her actions. I provided evidence that was handed to me by what I thought was a credible source, she said. If some of that evidence has been questioned, that doesn't eliminate the bigger issues about judicial independence that many Americans have. The host insisted, but don't you regret not verifying the simple timeline before publicly accusing a Supreme Court justice of such a serious crime? Bondi hesitated before responding. I believe that I did diligence as best as I could with the information before me. If there was something mistaken in doing it, then I'll accept the blame, but I refuse to apologize for challenging difficult questions concerning our institutions. Political backlash reached farther than Bondi and Barrett. Lots of senators who had happily followed Bondi's accusations while still unproved now found themselves pressed to answer to them. Meanwhile, those who had stood by Barrett all along were vindicated. Constitutional scholars noted that, whatever the outcome would ultimately be, the incident exposed some important information regarding the frailty of public trust in American institutions. One of America's top law professors said, when accusations this explosive ring plausible to millions of Americans become, or whether ultimately they prove false, it shows a crisis of trust in the Supreme Court that should trouble everyone. A week later, investigative journalists found serious discrepancies in the whistleblower's history, raising serious questions about their motives and credibility. The person had clearly never held the positions they claimed, but had managed to acquire sufficient inside information to create credible-looking documents. But the most lasting fallout ran through an unexpected channel. 2 weeks later, the Supreme Court issued new transparency measures on justices' meetings during confirmation. While not explicitly responding to the Bondi incident, the new procedures required recording of substantive pre-confirmation meetings and more transparent disclosure of possible conflicts of interest. In a rare interview, an older Supreme Court justice who was not involved in the controversy admitted, while the specific charges proved unfounded, they raised good questions about the court's accessibility. Sometimes it takes a crisis, even one based on mistaken premises, to stimulate necessary institutional change. For the public in America, The theatrical standoff between Barrett and Bondi was yet another reminder of how hard it had become to distinguish fact from fiction in politics. Ironically, the incident reinforced the need for evidence, context, and systematic verification in an era of instant accusations and viral outrage. 6 months prior, when Justice Barrett wrote the majority opinion in a milestone case that pushed back against the false documents claim regarding her, many took it as the ultimate validation of her independence as a judge. Others were uncertain, however, whether the public pressure affected her decision-making in ways that could not be measured. The lesson of the story was clear. In the charge politics of America, charges could make the rounds of the world before facts could even tie their shoes, but facts laid out in straightforward and orderly fashion still had the power to win out. Thank you for watching this detailed breakdown of the Barrett-Bondi standoff. If you enjoyed this commentary, please like this video and subscribe to our channel for more in-depth coverage of political showdowns that are typically misrepresented by the mainstream media.